So, good morning, everybody, and I thank you for joining us in this seminar on personal information protection legislation in China. I thank, first of all, Professor Wu Xuan, who will give us his presentation on this topic, and Professor Chiara Alvisi, who is one of the major experts in Italy on data protection regulation, will give us some final remarks on the presentation of Professor Wu. As you know, one of the aims of our research project is to provide European companies who are interested in investing and developing their presence in China of information about the main aspect of China is the regulation on business activities, and in particular on problems that they could face during their activity in China. Of course, the theme of data protection is one of the major new China and European regulation, as you know, that is creating problems for European and Chinese companies operating in the market, and therefore we are very grateful to Professor Wu Xuan, who one of the person which was involved in the development of the new Chinese regulation on data protection, to inform us about the main aspects of such regulation and the problems that are arising. Professor Wu Xuan joined the Shanghai Normal University Law School as associate professor in 2019, and currently also as the director of the Center for Cyberspace and Data Law of Shanghai Normal University. He's also the executive director of Yale Joint Research Center for Law and Policy Reform. Before coming to Shanghai, he was a senior research fellow at the Chinese Academy of Cyberspace Studies and Bureau of Policy and Regulation Cyberspace Administration of China, and postdoctoral fellow at Tsinghua Law School. He received a PhD from the East China University of Political Science and Law, and during 2011 and 2012, he studied Roman law at the University of Tor Vergata in Rome. He served in the National Legislative Branch, and he has engaged in research on cyberspace law for a long time, and has participated in some legislation work focusing on data cross-border, cyberspace security, data governance, and personal information protection and other cyber law fields. So thanks again, and you have the floor, Professor Wu.
Okay, let me share my PPT. Okay. Buongiorno a tutti, sono Wu Xuan, docente nella facoltà di giurisprudenza dell'Università Nazionale di Shanghai. Grazie mille per l'invito del professore Zunarelli e grazie per i commenti della professoressa Alvisi. È un grande piacere e onore essere qui oggi per discutere i temi e questioni sul sistema legale cinese. Mi ricordo bene i miei giorni a Roma, in cui studiavo il diritto romano con il professore Schifani. Mi dispiace che io faccia il discorso in inglese, perché ora ho quasi esaurito le mie parole italiane con cui di solito riesco solo a guardare le partite di calcio. Today, I want to introduce the personal information protection legislation in China. It is meaningful to discuss this latest legal issue at the oldest law school in the world. As we all know, the personal information protection law of the People's Republic of China come into effect on November 1st, 2021. I was lucky to take part in the legislation, and the act is considered to be a landmark legislation in the field of personal information protection in China. It is also the first systematic and comprehensive act aimed at protection of personal information. I will explain my introduction from three aspects. First of all, I want to talk about the background of the legislation. In my opinion, there are three main reasons for Chinese lawmakers. The first is the responding to the challenge of the digital society. We are in the digital age, and the technology is constantly changing our lives, such like big data, AI, blockchain, and everybody talked about these days, the net. Our daily lives is inseparable for the smartphones and the various of apps. When I was in Italy, there are some guys told me there is a very common word between the lovers. I think it's the non posso imagare il modo senza di te. But I don't know if my pronunciation is good. But I think today we cannot live without my smartphone. Okay, so that's very important for the lives. For example, in China, everyone uses the smartphones to shopping, order takeout food, take transportation, pay the bills, and do everything. So the online platforms collect and analyze our personal information through the smartphone to improve their service. But where the digital society brings convincible to life, it is also raises many challenges. Just like the personal and the property damages caused by the misuse of personal information, such like the internet fraud. There are so many sad stories in China because of the internet fraud. Because there are criminals, they use our information so they can take our monies and some other properties. Okay. The second is the privacy crisis caused by personal information leakage. And what is more serious is the loss of human subjective status and the subordinary of algorithms, which is called the loss of human dignity. About this, I think Max Weber once described in his age the law of the European as judicial vending machines, which is devoid of human emotions. But in our days, today, the court are developing the AI assistant judicial systems. I don't know if the designer of these systems have human dignity in their mind. Maybe the history will tell us the answer. Okay. Then then is the second reasons of the legislation. The second reason is the following international legislative trends. Okay, during the January 2021, there are 129 countries and areas have enacted legislation to secure the protection of data and privacy. So the data privacy legislation is a common goal pursued by countries around the world. There are so many famous personal data protection laws, such as the European, the GDPR, and the American, the CCPA. They all have a global impact. And in the data across boundary regulations, most countries do not allow the personal data to flow to the countries with a low level of protection. Such as the GDPR, the Article 14.4 of GDPR, it said all provisions in these chapters shall be applied in order to ensure that the level of protection of natural persons guaranteed by this regulation is not undermined. So to develop our data industry, a legal protection system that is in line with the international standards must be established. Okay. And then there are third reasons. Okay, it's the complete our systematical legal construction. You know, China has a long recognized the importance of legal protection of personal information. As early as 2012, the Standing Committee of the National People's Congress in the Congress studied the legal protection of online personal information in the form of a decision. And this decision is the same equal as the law. So after that, the protection of personal information has been included in many important legislation. In particular, the Civil Code of the China enacted in 2020 is the first one in the world that explicitly proposed the protection of personal information. Okay, but the relevant provisions are scattered in various laws, cause the protection effect to be reduced in practice. The experience of GDPR has made the legislators realize the importance of the systematic protection. Therefore, combined with the local experience in China, the personal information protection law was formulated. Okay, that's the first aspect. Then I will talk about the PIPL, the structure and the contents. Okay, let's first take a look at the structure of the PIPL. The Act consists of 74 articles in 8 chapters, which is namely the general provisions, the personal information processing rules, the rules for corresponder provisions of personal information, individuals' rights and obligations of the personal information processors, the Department of the Performance Personal Information Protection functions, that is something about the administration, and the legal liability. Okay, so it's a full and a systematic law, I think. And then the PIPL defines the personal information. That's the first time in China. It is as all kinds of information relating to identified or identifiable natural persons recorded by the electronic or other forms, excluding anonymous information, just like the personal data in Europe here. And then it also clear the possession of the personal information. Okay, that's the second. After that, the law then provided for the individual rights. The individual rights, which is about the right to know and to decide relating to their personal information, right to restrict or prohibit the processing of their personal information, and right to consult and copy their personal information from the possessors, and right to the portability of their personal information, right to correct and delete their personal information, and there are others. There's one provision very interesting. It's about the close relatives of a natural person can exercise their rights for their own legitimate and justified interest after the natural person is deceased, unless the deceased has made other arrangements when she or he were alive. Okay, so that's I think that's the point. That's a very interesting thing. Yeah. Then the PIPL imposed various obligations on the process of personal information, which is about the formulated internet management systems and operation procedures, and implement classified management of personal information, and adopt corresponding technical security measures such as encryption and de-identification, and something like that. After all, the certain companies are subject to more obligations, such as upholding a personal information protection office or an independent supervisory board, conducting private impact assessments for the processing activities, and punishing regular social responsibility reports. Okay. In the event of the data incident, processors are required to take immediately remedied measure and notify the PI protection authorities and any affected individuals. Okay, and if the processor fails to meet its obligations, it will face the servant penalties. If the violations of the PIPL may lead to an administration fine of up to 15 million RMB, or 5% of the processors turnout in the last year. So it's very high fine. Okay. The PIPL also provides more clearly on the allocation of responsibilities between the authorities, and refers to the central and the local governments with responsibilities under the laws as the authorities perform personal information protection duties and responsibilities, which means the PI protection authorities. And the allocation of the responsibility is as follows. The National Cyberspace Administration, also the CAC, the Cyberspace Administration of China, is responsible for the comprehensive planning and coordinating of the personal information protection and related supervision and administrative work. So after that, the relevant ministries and department of the state council, that's the central government, for the personal information protection, as well as the supervision and administration within their respective purviews. And the relative department of local governments at the county level, or above, will also perform certain duties and responsibilities with the respect to personal information protection and related supervision and administration in accordance with the regulations of the state. So, as is usual with all the Chinese laws, many of the concepts of these laws and requirements are high level, and we expect that some further details will be provided in regulations and practical guidance in the coming months. There are several guidance is already announcement. Okay. Then the third, I want to talk about the characteristics of the PIPL. In my opinion, there are three balance. The balance is the most important things of these laws, and there are three balance in PIPL. First of all, from the perspective of legislation purpose, this act focuses on the balance between the protection and the use of the personal information. The first article of the act shows cumulative legislative purpose. Okay, we can see for the purpose of protecting rights and interests on personal information, regulating personal information processing activities, and promoting the reasonable use of personal information. In my opinion, the relationship between these three legislative purposes is the protecting the rights and the interests of personal information is the prerequisite and the regulating and the reasonable use is the means, and the promoting the ordinary flow of the personal information is the ultimate goal. Therefore, a balance should be found between the protection of rights and the use of the personal information. After that, the chapter structure of the personal information protection law also confirms the above point of view. This includes the chapter 4, chapter 2, and the chapter 3 focus on the personal information processing rules. And the chapter 4 stipulated the rights of individuals, and the chapter 5 is about the obligations. So the chapter 4 and chapter 5 are the development around the former two chapters. The main concerns of the Act is to establish rules for the personal information processing. Through the legal regulation of the personal information processing activities, the Act is in order to achieve the goal of stable and healthy development of the digital economy. Therefore, the Act is not only the personal information protection law, but also the personal information processing regulation law. Okay, that's my opinion. And the second, This act focuses on the balance between the individuals and the processors of personal information. In practice, the status of individuals and the personal information processors is not equal. There are three main reasons for this. First, the concealment of the means of the personal information collection. If the personal processor doesn't fulfill the obligation of the notification, it is difficult for the individuals to find that his or her information has been collected. Okay. The second is that the use of personal information is not enough transparent. The new technologies such as big data and AI has improved the efficiency of data processing, but it is also consistent technical thresholds, just like the black box. It is difficult for the normal people to understand how their information is used. And third, the causal relationship of personal information infringement is difficult to prove. It is very difficult for the individuals to prove that the damage of their own rights and interests is related to the relevant links in the processing of personal information. Therefore, it is difficult for the traditional judicial remedy models to protect the rights and the interests of personal information. So, because the cost of individuals claims too high, the legislator and the authorities should prove the assistance necessary. This is what personal information protection law does. On the one hand, the law grants relevant rights to individuals. On the other hand, the law clarifies the obligations of personal information processors, which restores equity between the individuals and the personal information processors. Okay, finally, this law focuses on the balance between the development of new technology and legal regulations. Many comments has mentioned that PIPL has fully absorbed the achievements of the world's personal data protection legislation and combined with Chinese local practice to construct personal information processing rulers with informed consent as a core. That's true, but however, it should be pointed out that consent is just one of the 7 legal bases outlined in Article 13 of the PIPL. According to the article, we can see the processing is also necessary for the conclusion of the performance of the contract, for the performance of statutory duties, for the response to public health emergency. That's very important. I think in our ages, and for the supervision by public opinion or disclosed by individuals or other legally disclosed. Okay, that's some. This full show that what the law provides is not absolutely self-determination of personal information, but the right to ask the state protection of the individual rights. Okay. Okay, the right to protection is not absolutely right. It must be considered in relation to this function in society and the balance against the other fundamental rights in according with the principle of proportionality. At last, please allow me to show some the situation of the public health incident or the emergence there are some QR code for COVID-19. The first is the authorized by the state council, so it's only for the central government. which is collect the individual movements. So to identify if you have traveled through the high-risk areas in the last 2 weeks, you can see now the color is blue, and there we can see this guy is in just in the 2 weeks, last 2 weeks, he's still in Beijing. Okay, so this is okay. And the last few of the health code as development by the local governments, it is required when the traveling across the regions or enter some public place, such as hospitals. When you go to hospital, you must show your QR card. If you don't have QR card, you are forbidden in the hospital. Okay. Through these measures, health and epidemic prevention authorities can detect risks and in advance to protect the health of the general public. So after all, I think the purpose of the PIPL is to promote the legally and reasonably use of personal data. The act emphasizes the respect of human dignity and the personal rights in the development of digital age. Okay, that's all of my talk. Thank you for the listen. If you have any questions, we can connect by email. Okay, thank you, Professor.
Thank you really a lot, Professor Hu. And I really appreciate your very comprehensive speech about the new PIPL and how in China it was possible to find a balance between the obligations of the processors and the right of the individuals and the different elements which are relevant for this purpose. Now I ask Professor Alvisi, she wants to submit us some preliminary comments on your speech and on the PIPL elements that you have submitted to us. Thank you, Chiara. You have the floor.
Thank you, Stefano. Can you hear me?
Yeah, yes.
Thanks, thanks. So I really would like to thank Professor Hu Xuan for his very interesting lecture on the People's Republic of China's Personal Information Protection Law, which came into force on the 1st of November 2021. I think that today we have the great opportunity of learning from Professor Hu what the main elements of legal protection of personal information are in China. I've been requested to make some final remarks and I thought it would be interesting to compare some of the aspects of PIPL that Professor Hu discussed and compare them with the EU GDPR, with also some reference to the US data protection legal system, so to highlight similarities and differences. First remark, I see that the PIPL is a general purpose legislation which applies to any kind of personal information that is processed by private organizations. A general purpose approach has been adopted also by the European Union GDPR. The EU regulation was approved in 2016 in order to reduce discrepancies arising from the 1995 Privacy Directive enforcement among the different EU member states, and to keep pace with ongoing technological developments. So GDPR strengthens individual rights and data processor obligations as well in order to regulate the digital market with the aim to enhance the free movement of such data but while keeping at the same time a human-centered approach. I would also highlight that both the regulations adopted by China and the European Union are very different to the privacy policy adopted instead by the US. In the US, with the sole exception of the state of California, protection is limited to sector-specific legislation that cover only certain kinds of information, mainly that involving governmental disclosure. In particular, the American approach to data protection has been described as a patchwork, given the sole existence of federal laws for specific sectors, such as children's data, phone records, cable subscriber records, video rental records, credit reports, medical records, and so on. So even the most comprehensive set of privacy laws, the Privacy Act of 1974, applies only to public bodies. As a result, private businesses are generally free to market data in the US, which is not the case in the European Union, and as we have learned today, nor it is the case in the People's Republic of China. Second remark, Professor Huxuan has told us that, quote, the right to have personal information protected, unquote, under the Chinese law is not, I quote, the right to self-determination of individuals regarding their personal data processing, but it is the right, quote, to protect people's personal information, unquote, requiring the state to provide protection. So regarding this point, I was wondering if Professor Huxuan could tell us something more about the Chinese legal understanding of the right of personal information compared to the European Union individual's right to personal data protection. As you know, data protection is a relatively new branch of law that in the West has developed from privacy discourse and has gained a central and independent role throughout the years. Both privacy and data protection confer to the individual the power to act against wrongful uses or disclosure of personal data. Yet, even if data protection derives from privacy law, it has some peculiar characteristics. On one hand, data protection has a broader scope of application since it protects also other fundamental rights, such as freedom of expression or free flow of information, in addition to the individual liberty and self-determination rights granted by private law. On the other hand, data protection is a narrower concept than privacy, since it only regulates the processing of personal data. We know that, notwithstanding their common roots, for instance, US and EU data protection system are consistently different because they have different interpretation of privacy. Even though both jurisdictions regard the privacy as a value of personhood, the approaches diverge since in the EU privacy is an aspect of the concept of dignity and autonomy, whereas in US it is an aspect of liberty. The EU recognizes constitutional rights for the individual regarding the protection of their dignity. Specifically, in the EU, data protection and privacy are protected under the European Convention on Human Rights and the Charter of Fundamental Rights of the European Union. Both of them recognize the right of privacy by mandating a right to respect private and family life, respectively in Article 8 of the Convention and Article 7 of the Charter. As for data protection, the Charter expressly recognizes the right to data protection under Article 8, whereas the Convention does not have a specific provision in this regard, even if the European Court of Human Rights has interpreted Article 8 of the Convention as encompassing even the right of data protection. Consistent with this, Article 16, paragraph 1 of the Treaty on the Functioning of European Union states everyone has the right to the protection of personal data concerning them. Given the status of fundamental right, the Treaty on the Functioning of European Union even lays down the obligation for EU competent bodies to enforce legislation relating to the processing of personal data. Also, the GDPR, which is the main body of EU law in this regard, recognizes the fundamental nature of the right for the protection of the individual in relation to the processing of their personal data, stating that, I quote, "the processing of personal data should be designed to serve mankind," unquote. In the US, instead, there is no constitutional right resembling the European protection. The US Constitution does not concern private relations nor oblige the legislator to enforce a regulation in this regard. Since it is based on the concept of freedom, it mainly concerns the relationship between the state and citizens. In contrast to the EU, it is not even clear whether and to what extent the American Constitution provides for data protection. In this regard, the main two provisions are the 4th and the 14th Amendments, which both concern public bodies. The 4th Amendment protects individuals from unreasonable searches and seizures, yet it provides a very thin protection, since generally the government's collection of data cannot qualify as a search or a seizure. Moreover, the US Supreme Court has embraced the third-party doctrine, which consider the government obtainment of data by third parties as outside the scope of the provision. Indeed, it held that when individuals voluntarily give their data to third parties, they have no legitimate expectation of privacy. So the constitutional safeguard for information access rather than for information privacy. In particular, the First Amendment protection of freedom of speech has already been, and it will be likely, used again by businesses to defend their collection and processing activities. Given that US constitutional law seems to be oriented toward the protection of data processor rather than of data subject. Regarding the PIP milestone of China's personal information protection legal system, as far as I have understood, the right to protection of personal information means the right to have personal information protected by the state in order to achieve the goal of stable and healthy development of the digital economy, as Professor Hu explained. To summarize, from a comparative standpoint, I think that in the EU, data protection means protecting individuals' privacy and in doing so, individual self-determination and dignity by broadly and deeply regulating both private and public entities' access to and processing of personal data. In contrast, in the US, it is personal information access and processing by private bodies that is mainly protected in the name of the freedom of speech and in keeping with the typical American belief in a self-regulated and market-based system in which firms are mainly protected as key businesses for economic growth, whilst in China, personal information is protected by limiting access and strictly regulating the processing thereof by private entities. Third remark, Professor Hu Xuan has highlighted that, I quote, "for individuals, the cost of protecting individual rights is too high. In order to protect the rights and interests of personal information, legal and regulatory agencies should provide support," unquote. Therefore, in the PIPL, I quote, "the premise of personal information processing is not limited to the individual consent, as the law provides at least 6 other legal bases for personal information processing without the individual consent." We know that EU GDPR is not centered around individual consent as well, since the data controller should rely on other legal bases to process the data when the consent basis is not appropriate. These and other GDPR provisions reflect EU skepticism towards a model based only on free and rational consent, which is due mainly to a twofold reason. The notice and choice model adopted by the GDPR has been criticized as being highly ineffective due to the many market failures affecting the digital market. Notice means here a document informing the individual of the processing of their data and choice of action, typically using the site or clicking on an I agree button, which is interpreted as the acceptance of the privacy terms. Nevertheless, this model presupposes an economically rational individual, fully informed and with equal bargaining power to the digital platforms, and such a person is, needless to say, unlikely to be found in the real world. Indeed, it has been shown that general consumers lack the proper knowledge to understand privacy policies and to make informed decisions. Firms often draft vague and complex privacy policies, reserving for themselves the option to change them at any time. Furthermore, given the considerable amount of time needed to read the policies and the complexity and technicality of the terms set out in them, users tend not to read them. For instance, one study has estimated that if a user were to read all the displayed privacy policies carefully, he would spend 244 hours a year, more than the total time spent surfing on the internet. So if there is too much information to be processed by an individual, this is called information overload. Moreover, consumers lack the financial strength to influence the terms of the transaction with online platforms. Actually, most internet transactions are take it or leave it deals. Additionally, consumers don't have the proper means to act in response to any breach of the agreed processing terms, since they cannot effectively monitor a firm's compliance with their own privacy policies. As a result of the aforementioned, consumers enter into unbalanced transactions in favor of data collectors. Another reason for EU skepticism of the consent model is the EU conviction that data protection is a fundamental right involving a degree of inalienability. In the EU, individuals cannot sell their data because once sold, they would lose their self-determination, which is also protected as a democratic social value. Yet, they can consent to the processing of their data since a commercial utilization of data within the limits set out by the law is deemed compatible with the fundamental nature of data protection. The EU legal framework empowers individuals, yet their consent under certain circumstances restricted. Thus, inalienability partly restrict the transferability and use of personal data by defining some areas where consent may not govern exchange and by preempting definitive assignment. This system of checks and balances embodies the two chief goals of the EU system, the protection of individual rights and the facilitation of the flow of data. In contrast, the US places strong emphasis on the requirement of consent, since it does not encompass the concept of inalienability. Indeed, it does not mandate the lawfulness of processing nor consistent limits to individual self-determination. This is due to the fact that the US system considers data protection from the market perspective. Accordingly, the individual is considered as a market participant, exchanging his personal data as a commodity. Therefore, in referring to the data subject, US privacy laws use the terms consumer, customer, subscriber. Given that the main intervention by the US legislator regards the fairness of these exchanges in the data market, and therefore the most important constraint imposed by federal statutes is notice requirement. Fourth remark. Professor Hu has highlighted the number of rights the PIPL grants to individuals whenever their personal information are processed. The same is the case with the GDPR, which grants a number of rights to data subjects regarding the processing of their personal data. And instead, in the US, individuals do not have the general right to access and correct their data unless specific statutes such as the Health Insurance Portability and Accountability Act and the Fair Credit Reporting Act allow them to do so. And my fifth and final remark regards Professor Hu's considerations about the need for the state to respond to the challenges created by technologies like big data, cloud computing, artificial intelligence, and so on. Indeed, in the era of big data, the three core strategies long used to ensure privacy, that is, individual notice and consent, opting out, and anonymization, have lost much of their effectiveness. In particular, there is a concern regarding the need of informed consent. It is contended that with big data analytics, a real informed consent is not possible, since once the data are collected, they are retained, combined with other data, and analyzed for a variety of other purposes with unpredictable outcomes. Hence, risk of unforeseen use and merging personal data are right around the corner. Indeed, asking consent for any future use of data would clash with the very notion of consent. The consent problem is aggravated by the fact that most big data firms retain monopoly power. Even if consumers were aware of the low monopolist privacy protection, they would not have readily available alternatives to switch to. However, it has been highlighted that the EU data protection authorities' scrutiny sets a proper counterbalance to offset the contractual weakness of individuals who, pursuant to Article 77 GDPR, can also lodge a complaint with the competent data protection authority. These are only few of the many challenges that big data have presented us with. As it has been told by Professor Hu, such challenges need to be addressed with a global strategy, given that the impact of big data is worldwide. However, even though the need for a global strategy is evident, it is far from being achieved. Indeed, even though EU, US, and China invest highly in this technology, given its high profitability and innovation opportunities, it is also true that these jurisdictions provide for very different data protection frameworks. This difference has a considerable impact, especially if we consider that most big data firms are US and Chinese companies, which operate also in Europe. This said, data processing raises concern, especially for EU citizens, insofar as they feel they are less protected under extra EU data protection law. This is the reason behind the EU legislator decision to mandate the extraterritorial scope of application of the GDPR. Such extraterritoriality may be seen as a tool to foster harmonization throughout Europe and other non-EU partner countries. Indeed, multinational firms may decide to extend compliance programs required under the GDPR also for their home consumers. This decision will essentially represent an investment in the quality of firms' products and services. However, notwithstanding the desirability of this outcome, it is very unlikely. Therefore, the only way to respond to big data challenges and risk would be for these jurisdictions to set an harmonized data protection framework. Hence, a reinforced cooperation in setting out common requirements for cooperation could be achieved so to ensure that the free flow of data is not hampered and personal data breaches and unfair practices are properly addressed. So I hope that this brief comparative overview has made it clear how important It is to study the Chinese PIPL in comparison with the EU GDPR and to know the underlying understanding of privacy and data protection issues within the respective legal system. It would be important to find out also thanks to research programs like the OBOR project directed by Professor Zunarelli and funded by the Italian University and Research Ministry, a way for developing and agreeing on a shared global strategy to regulate digital markets in all the countries involved. So thank again, Professor Hu, for your brilliant lecture, and thank you all for your kind attention. So now I leave the floor to the chairman for question time.
Thanks a lot, Professor Alvisi, and I think your remarks were very, very interesting and precise on several points of Professor Hu's presentation. I would like to ask Professor Hu, first of all, if he has some comments on just some of the remarks which were made by Professor Alvisi. You have the floor if you want, Professor Hu.
Thank you for the Professor Alvisi. It's a very, very wonderful comments. And I think I agree your appointment. There is very different between the Europe and the US in the data privacy. So when China, we do our legislation, we have some argument. There are some studies they want to learn the US, and others they say that GDPR is perfect. So at last we don't. It's maybe our PIPL is similar with the GDPR, but we have our own situation. So we do some element from the GDPR. So I think it is very interesting because the data privacy is about the culture of the people. So in China, it is totally different privacy. They think because just like the QR code, because the healthy in China, most people they think it's okay for our location, the information we give the government, so it's totally fine. But maybe in US and in European, it's about the human rights. So I think there are much more studies we could do to compromise our two kind of the laws. Okay, thank you very much.
So thanks again, Professor Hu. I've seen that Mrs. Genovese has asked for questions from the floor, but there was no reply to that request. So I really thank again both of you. I think this seminar was very interesting, and some similarities and some also important differences have emerged between the European and the Chinese approach to the data protection problems. But I think that this has been a very useful first opportunity to make such a comparison, and maybe we will have the opportunity in the future to enter again these problems and to go further in deep in the analysis of some of the problems, at least, that have arisen. So thanks again to Professor Hu and to Professor Alvisi and to all the people that have attended to the seminar. And I really hope to have the opportunity to meet again on a further seminar in the near future with both of you. Thanks again. So bye-bye to everybody.
Bye.
Thank you.
All the
Bye.
best.